Hi, I'm Sarah Harper. I'm an attorney at Warner Norcross and Judd. I'm in the Mergers and Acquisitions group and specialize in investment advisor and broker-dealer transactions. So today we're going to talk about getting ready to sell your investment advisory business. There's a few key areas to touch on. The first, important first steps when you decide you're ready to sell. Second, how to prepare for the transaction. Third, due diligence. And lastly, regulatory issues. So first steps. The first thing you should consider is why you're selling your business. What are your motivations? Are you looking to retire? Do you want a career change? Do you want to merge with another firm and keep servicing your clients? So that why is really going to guide the whole process and the structure of the transaction. Next, identify the type of buyer you want to work with. Is it someone who aligns with your business values? Do they cover the same geography you do? Do they have additional capabilities and service offerings that you want your clients to have that they currently don't? Do they currently offer similar products and services? So all those things are important to pick a buyer that's going to be a right fit for your business. If you're selling to another business partner and you're retiring, obviously the transaction is going to be a lot easier. But when you bring in a third party, the process will take a bit longer because they're going to want to do due diligence and the transaction negotiations will take some more time. Next, you're going to want to come up with an ideal valuation for your business. So what do you think it's worth? That's going to be based on your AUM, your client relationships, and historical cash flows. Next, consider some key deal terms that are really important to you. That could be that minimum purchase price, the timing of payment. Are you going to accept a promissory note? Will you receive an earnout over time, or do you want cash up front? There could be a non-compete that is important to you, maybe not so much if you're retiring, and there's a lot of things to consider when you're entering into a deal. And lastly, you're going to want to engage a trusted advisor like Warner Norcross and Judd that has experience in both the mergers and acquisition space and the investment advisory business so they can guide you through the transaction. So the first step to prepare for a potential sale is to gather and organize your books and records. This is going to include client contracts, vendor contracts, and regulatory information, as well as your financials. Potential buyers are going to want to conduct thorough due diligence on your business, and getting ahead of that will ensure a smooth transition and avoid any delays in the diligence process. Next, assess any potential regulatory risks your business may have. Some sellers will conduct a mock exam to identify any issues. If you want to do that, we always recommend engaging an attorney to assist with that process to ensure it's protected by attorney-client privilege. Third, you're going to want to consider how that sale could affect your client relationships. If you continue to service your clients after the transaction, for example, if you stay on as an employee of the buyer, you still need to notify your clients of the transaction and discuss how their relationship with you will change. But if you are exiting the business, for example, if you are retiring, then that needs to be clearly communicated to your clients as well and done in a way to help the buyer maintain those important client relationships. Fourth, consider how a potential buyer will integrate your business into theirs and if there's any key operational considerations or other items you want to look at. And finally, communicate openly with your business partners, shareholders, and board of directors to ensure the entire organization is aligned on the transaction. Next up is the due diligence process. It's important to maintain confidentiality throughout the transaction to avoid disrupting your client relationships or potentially alarming employees. Enter into a non-disclosure agreement with any potential buyer before confidential information is exchanged to protect that information. The buyer is typically going to provide you with a very detailed due diligence request list. It's important that you're transparent in your disclosures and you provide all information requested. However, the timing of diligence disclosures is also very important. You have highly sensitive information about your clients, and it may make sense to retain or redact some of that information until the transaction is at a more certain stage. While the buyer is conducting due diligence on you, you will also want to conduct due diligence on your buyer. There's a few things you should look for. Do they have the financing necessary to complete this transaction? What is their regulatory history? Would you recommend them as a trusted advisor to your clients? How does their investment style and product and service offerings compare to yours? And do they bring anything new to the table, potentially products and services that you don't offer your clients that could be a benefit? You'll also want to examine your current client agreements and other key business contracts to determine whether those contracts could be transferred to the buyer and if there are any other legal or regulatory considerations to be concerned about with that transfer. Next, discuss your current compensation arrangements you have with employees and other representatives of your business. There could be deferred incentive compensation arrangements that may be triggered by the transaction. Now, your book of business is your most valuable asset, and it will be a topic of key due diligence for the buyer. The buyer will want to understand the types of clients you serve, including their geographic location, net worth, and their investment profiles, your investment strategies, and the type of billing you use, among a lot of other information. Determine the best way to exchange information with the buyer that is both secure but not overly burdensome. A lot of parties like to use online data rooms and other file share sites to conduct this process. Finally, lean on your trusted advisors throughout the diligence process. Diligence is not the most fun part of a transaction, but it is extremely important. There are some key regulatory items to consider when selling your business. Client consent is potentially the most important. The consent of each of your clients is required to transfer their business from you to the buyer. This can be generally obtained through either positive consent or negative consent. Positive consent is the process by which your client affirmatively acts to transfer their business. This could be by signing an assignment agreement or potentially entering into a whole new agreement with the buyer. Negative consent is a passive process by which a client's business transfers to the buyer after you've notified the client of the sale and a set time has passed. The terms of your specific client agreements will govern this process. Additionally, if you're a broker-dealer and FINRA member, FINRA approval may be required before you can complete the transaction. If you're an advisor to a registered fund, the approval of the board of directors and shareholders of that fund may also be required, which can be a very lengthy process. Finally, on the buyer side, depending on the size of the transaction and the location of the clients being acquired, the buyer may need to register with the SEC or complete new state registrations or notice filings. If you'd like to learn more about the M&A process or selling your investment advisory business, please check out the other great videos Warner has on our website or contact our team.